Hello, you're welcome to PPL518 Alternative Dispute Resolution 2. Remember what I said that in this course we are really looking at arbitration because of how significant and how important it has become over the years. So we're going to be looking at another topic on arbitration that will enrich your knowledge and make you better as you make progress in this course. Remember what we always also say, that to get the best out of the course, we must take our notes, we must take part in the activities. We shouldn't be ashamed to ask questions if we have any. So let's not waste time. Let's go and see what interesting thing we are learning today. Okay, so in this lesson, at the end of the lesson, you should be able to define what we mean by the law governing arbitral proceedings. You must be able to define and analyze the C theory and explain the principle of the localization. Then you should also be able to define relevant Latin terms and apply them in arbitration. So let's quickly go to our definitions. What is lex contractus? It's a Latin term that means the law governing the main contract. That is, usually an arbitration agreement will expressly state that this agreement is governed by. For instance, if you look at the P&ID agreement, it says this agreement shall be governed by and construed in accordance with the laws of the Federal Republic of Nigeria. So that the laws of the Federal Republic of Nigeria in that context is the next contract. Procedure like um, the powers and duties of arbitration, when to introduce evidence and all of that, those are under the next foray. So for instance, if you look at the precedent given by the Stockholm Chamber of Commerce, any dispute settled, any dispute, now I shortened it, without giving all those other details. So any dispute between the parties, whatever, should be settled by arbitration in accordance with the arbitral rules of the Arbitration Institute of the Stockholm Chamber of Commerce, which means that the next foray in this case will be the arbitral rules of the Stockholm Chamber of Commerce. Okay. Parties do not expressly state what their choices are. Inferences will be made from the circumstances of each case. Um, Arbitration, you remember we talked about consent, very important. So parties, tying that to the party autonomy theory, parties are free to construct their contractual relationship as they deem fit, including what their next arbitration should be. However, you have to note that the contractual theory is still tied to the jurisdictional theory, in the sense that the lex loci arbitrary, remember what we said about the lex loci, the law of the place where the arbitration is taking place, it is important because they are the existing legal system, and whatever parties agreements parties have, they confer it on them. And you remember what we said about how it ties in with arbitrability and all of that. Going on, you may need to note that first of all, the next arbitrary, even though parties are free and all of that, the next arbitrary may conflict with a different law, whether or not that law is relevant. That is where the example we gave about the next local arbitrary comes in. So if arbitrability is an issue, it doesn't matter what the next arbitrary will be, enforcement may become a problem. Also, the next loci is important because arbitration does not take place in space, right? It takes place within a location. Parties will depend on the laws of a particular notation for enforcement of their awards, so it's important. Then it is very important when you are choosing all these, the next foray, the next arbitrary, if you ever deal with all next contractors and all that, to exercise caution, because you don't want to give powers to parties that you don't intend to give power to. Okay, so now to our first activity, I would like you to differentiate between the lex arbitrary, the lex fori, and the lex contractus. Take a few seconds to think about your answer, and then we will move on to the seat theory. That the seat of arbitration may be expressly stated, and we gave examples, or it may be implied from conduct of parties and so on. So if you look at two examples we have given here, in the Abuja Hotels and Meridian Agreement, it was expressly stated arbitral proceedings shall take place in London before the International Chamber of Commerce, and that was, interpreted by courts to mean that the seat is London. Now, if you look at the P&ID case, parties simply said venue of arbitration shall be London, England, and the courts inferred from the parties' conduct and from Section 16 of our Arbitration and Conciliation Act that the parties intended for the seat to also be in London. Said it can be expressed or implied. Okay, and I gave examples in the previous slide. It's important that you bear in mind the implications of, selection of the seat, the implications of the seat theory, the implication of a particular location being selected as the seat of arbitration. Because where the arbitration agreement is silent on the law that should apply to the arbitration and the arbitration clause, of course the law of the seat will apply. The principle of lex arbitri. And then the courts in that particular place, the court in the seat, are the ones that will have supervisory jurisdiction. It doesn't matter whether the contract was going to be performed in a different place. And then, of course, when it comes to recognition and enforcement, and challenging and back and forth, the courts of the seat are very important. Means that you cannot depend on a particular location or the rules of a particular location. And then again, they are of the opinion that it is no longer necessary, because following, the, would I say, attractiveness of international commercial arbitration or international arbitration, every country now wants, to be more liberal in order to attract international arbitration. So really, those rules that parties will be afraid of, local rules that parties will be afraid will not favor them, have been jettisoned, particularly since the UNCITRAL model laws has enjoyed general acceptance. Majority of countries have, drafted their laws, copied exactly or drafted their laws in line with the model law. So the risk of hijack by national laws has been reduced, or it is, non-existent. To our second question, I want you to think about what we said about the delocalization, and what do you think, are the advantages and the disadvantages of delocalization, on the basis of what we have discussed about it. So let's take a few seconds and think about that, and then we'll bring the class to an end. Okay, so we have gotten to the end of this class. We have looked at, the laws that will be applicable to arbitral proceedings. We have tried to define various Latin terms that relate to this. We have also explored the seat theory. So if you have any questions, please feel free, post it on the discussion forum, and then we will try and answer it. And you also know, of course, that you can download the video and watch it over and over. I know this is a bit technical, can be confusing because of all the terms are like lex, but what I would advise is watch the video again and again, and then you will get used to the different, slim differences, and it will become clearer. So until our next lesson, take care and thank you for watching.